Yeah, some people say that solves the problem, but then some people say it just complicates things.
Is it like this swallowing a spider to get the fly?
Court is calling CM 114217, 114220, and 114222, State of Texas versus Virginia. Cerna, can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Michael DeLeon for Ms. Cerna.
And are you Ms. Cerna?
Yes, ma'am.
We are here, counsel, for a bond reduction. Is that correct?
That's correct. Just for the record, Your Honor, originally Ms. Cerna was charged with aggravated assault with a deadly weapon. Her bond was set at $15,000. That occurred early in 2023. She, in late October of 2023, picked up 3 charges of aggravated robbery, which we very much dispute. And because of those robbery charges, her original bond on aggravated assault was remanded without bond. Okay, so today we're going to.
Just one moment. And the court will also be calling 2023 CR 5815. You may continue, counsel.
And today, Judge, we're going to be asking that a bond be set in her aggravated assault charge, and the associated aggravated robberies are set at $75,000, which is highly excessive. Before we go to the facts of those aggravated robberies, we're going to be asking for a bond of $10,000 each on the aggravated robberies, given the circumstances.
All right. And what bond would you be asking for on the aggravated assault?
It would be ideal to reinstate her bond at $15,000, but we will go with whatever the court wishes to do.
All right. And state, are you prepared to proceed?
Yes, ma'am, we're ready.
Any witnesses? State or defense?
None, Your Honor. I do have, I'd like to give the court a packet. I can do it one of 2 ways, either, and I've shown this to Mr. Wilkins, series of pictures, and I've marked it as defense exhibit number 1. I can have my client identify it, or as an officer of the court, I can identify what those pictures are.
All right. Any objections to defense exhibit number 1?
No objection, Your Honor.
All right. Then the court will set exception to evidence defendants exhibit number 1.
And if I may, Your Honor, what the court is looking at in defense exhibit number 1 is the first photos are of the 3 complainants in the case. The very first picture is who is the biological son of my client. He was not raised by Ms. Cerna, but they are biological. And the other 2 are friends of Mr. Cooper. Additionally, you're also seeing social media posts of the various complainants and their various photos with weapons, with smoking blunts, with putting up wads of cash with those weapons as well. And lastly, there are injuries to Ms. Cerna's arm that occurred during that robbery. And we do want to address that when we get to that point. But that very last photo is a kind of fresh photo, and it's kind of hard to see in the black and white versus color, but she was cut by one of the complainants.
The court sees defense exhibit 1 with the alleged complainant listed. The court sees what appears to be the complainants holding AK-47s and Glocks.
Yes.
And then the next photo appears to be the complainant, who is the defendant's son, holding cash, wearing pants that are 30 sizes too big, that are sagging. Then the next photo appears to be 2 complainants with someone with a gun, but there's no face to the person holding the gun, pointing the gun at them as they smoke blunts and photograph the person pointing the gun at them. Then the next photo appears to be someone holding a gun. And I believe that's the complainant that is listed on page 3 of defendant's exhibit number 1. And then the court sees photographs with no face. So I don't know, I'm taking you at your word saying this is your complainant, but there's no face, but it appeared There's no talking by you unless you're under oath. But I do see photographs that appear to match the mark that's on your client's arm, but again, her face is not pictured in defense exhibit number 1.
As an officer of the court, I will say that I've talked to my client. She has identified the 3 complainants, that being Jonathan, Joseph, and Christopher being the ones in the photos. And I'll also point out to the court that these photos taken from social media were my client got those while she was out on bond, and was able to forward that to me before she was taken into custody on these new aggravated robbery charges.
Okay.
Additionally, Judge, if you look at the facts and circumstances of the case, I know we're not here to litigate the entire aggravated robberies, but there's an allegation that Ms. Cerna and her husband pulled out guns after inviting her biological son and his friends over to a La Quinta to see a just under 2-year-old stepsister that was born that Mr. never met before. Suddenly a robbery occurs allegedly with firearms by Ms. Cerna and her husband allegedly. However, if you look at the facts and circumstances again, La Quinta management throws out everybody out of the hotel. There's an argument going out in the parking lot when supposedly my client and her husband have firearms, yet somehow these complainants are hanging around in the parking lot with them when they've just been threatened with firearms. Doesn't make a lot of sense. Additionally, Ms. Cerna does have that injury to her arm. She was cut. Once again, if she had a firearm, she wouldn't be in the position to be cut by Jonathan Vidales, who is in fact, all of these are, well, actually, Jonathan and Joseph are juveniles. Mr. Cooper is, I believe, 18 years of age at the time of this event in October of last year. But the circumstances are very suspect, Judge. So without going in, and obviously this court is not going to make a judgment on the veracity if she's guilty or not guilty of those specific aggravated robbery charges. But given the circumstances for setting a bond, we believe that because of the nature of the weirdness essentially of this allegation, we're asking that bonds be set of $10,000 on the aggravated robberies so they can be litigated down the road. And we'll see further in the future if, and this case is unindicted. These 3 charges have been unindicted for the past roughly 60 to 90 days. We will see if the district attorney's office will even go forward. I mean, obviously, Mr. Wilkins might know more about if they even have complainants that are going to be continuing to complain in the future. So based on that, Your Honor, and the circumstances, we're asking that the bond be set on the aggravated assault and a much lowered bond be set on the aggravated robberies. Obviously, if the court wants to do GPS, that is more than fine. We might ask the court to reduce or waive GPS fees, but if the court wishes to do that, we need more. Ms. Cerna will certainly comply with all GPS conditions.
All right, state.
Yes, Your Honor, we are asking that you double the bond on the aggravated assault deadly weapon from 15,000 to 30,000. And we're asking that on the aggravated robberies, that you keep the bonds at 75,000 each. We're also asking that you, she has these conditions of bond, the special conditions of bond, Judge, that I attended to the court. We're asking that you keep the GPS with full house arrest in place, no contact with the complainant witnesses and the aggravated robberies. A prohibition on possessing firearms. And Judge, I've previously tendered to the court the police report. I didn't mark those. I have stickers here if you'd like to.
If you mark those as states exhibits 1, 2, and 3.
Yes, sir.
And defense, have you had a chance to review those documents?
We have, Your Honor, no objection.
All right, then states exhibits 1, 2, and 3 are admitted. And of course, defendants exhibit number 1 is admitted. And you can tender those to the court reporter. I've reviewed those.
Okay, yes, ma'am. So just
And
reading.
I'm sorry, just so the record can be clear, those were reviewed before they were offered into evidence, and both the defense and the state requested that the court review those before they were offered into evidence.
Objection.
Just, real briefly, the argument, in the police report, these are, very serious allegations. We're asking, that the bond be set at this high, or kept at this high number, in order to protect the community. The code says that you can set reasonable conditions of bond. We think under the facts alleged in this, police report, these are reasonable conditions, this amount, as well as your full house arrest GPS. And if you were inclined to grant a lower amount of bond, we would still ask for the other conditions, the full house arrest GPS, Judge. But I reviewed those pictures, and I think some of the questions that maybe the court had too. This is a picture. I don't really know what this is depicting. This could be an airsoft gun. This could be a real gun. These guys could be engaging in blunting, or this could be tobacco. A couple of these guys are juveniles, so if they have guns in these pictures that are undated, I think. We don't know when that is. I don't think any allegation that at the time of the offense, October 27th of 2023, that any of the complaining witnesses had guns at the time. That's not in any of the police reports. So, Your Honor, in order to protect the community, we are asking for those bond amounts as well as the full house arrest GPS, Your Honor.
And lastly, Judge, if I may, what I forgot to mention was nowhere in that police report does it say that anyone beyond the complainant said that Ms. Cerna and her husband had firearms. The hotel manager was told she had a firearm, but never saw it. So I want to be real specific about that.
And just briefly, I mean, when I was reading the police report, if you're in a hotel room, I don't typically invite the manager into the hotel room. So I don't know how we would see if there are guns or not in there.
This is as everyone was exiting, all the parties.
Okay. So is there anything else from either side?
Just a few more things. No, I'm just kidding.
All right. So I'm going to keep the previous conditions of full GPS. I'll ask that the fees be waived. For the aggravated assault with a deadly weapon, I'm going to set the bond at $25,000. And that is cause number 2023 CR 5815 and CM number 114217. The court will reduce the bond to $60,000. And that's based upon what the court has reviewed in the police report. And cause number CM 114220, the court will reduce the bond to $60,000. And in cause number CM 114222, the court will reduce the bond to $60,000. And there's to be no contact with, is your husband Ruben Cerna?
Yes, ma'am.
There's to be no contact with Ruben Cerna. All right, is there anything else?
Nothing, Your Honor. Thank you.
All right, Ms.
Oh.
Ferguson, we need a jury trial date, a quick date on this case. State, how long do you expect this trial to last?
3 days, Judge.
All right. So that means it'll probably be 2 days. The earliest date you have. All right, we'll come back with jury trial on February 6th. If you're still in custody, you'll be brought over and trial dressed in whatever civilian clothing you have at the jail. If you wish to be attired in something else, you'll need to do a clothing exchange. Mr. DeLeon, if there's an issue with the clothing exchange, let the court know.
Yes, Your Honor. We thank the court.
All right, and do you know if your client will be going, if she were found guilty, do you know if she'd be going to the court for punishment or the jury?
We haven't discussed that yet, Your Honor, but probably the court.
All right, on Eric Lopez? All right, thank you.
Thank you, Judge.
Y'all move it to that end?
Yes.
Okay. Court is calling 2016 CR 6340, State of Texas versus John Anthony Ramirez. Could I have parties announced for the record for the state?
Danny Westport, State of Texas.
Defense?
Renee Munoz on behalf of John Ramirez.
Are you Mr. Ramirez?
Yes, ma'am.
Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same John Anthony Ramirez who was placed on deferred adjudication in 2016 CR 6340 for the offense of aggravated assault with a deadly weapon on April 10th, 2017 for a period of 5 years and extended for a total of 3 years? All right, state.
Violated condition number 5 in Bexar County, Texas, the defendant, John Anthony Ramirez, did then and there fail to report to the supervision officer as directed for the months of July and August 2023 in violation of condition number 5.
How do you plead to that? True or not true?
True.
Your Honor, state waives all the violations.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 5? Court will find violation of condition number 5 true. Is there a proposed agreement?
Yes, Your Honor, we have already proposed probation. It's for the defendant to, report twice a month, for 3 months virtually or in person. Monthly UAs, for the defendant to continue treatment, with the Center for Healthcare Services and to comply with his medications. And that would all turn him in, and we would ask that he did not.
All right, probation.
Your Honor, we did confirm that agreement to change. I'm sorry, the agreement is not. That is the agreement.
All right, so here's the court's issue. He's been here before me previously for not reporting. So how is this going to solve the issue? And I'm taking in consideration his mental health issues. So how is this solving the issue?
Yes, Your Honor. At first glance, I can see the court's concern. I spoke with my client and he did state that he was and is currently receiving services with the Center for Healthcare Services, Judge. He has been prescribing to them. I am receipts of a document from Jennifer Munoz, his case manager.
Mhm.
I can tender it to the court.
Yes,
the court
please.
doesn't have an issue with that. He's been under their care for the last 18 months, Your Honor. and been-
All right, you all need to whisper in the box. If you can't whisper in the box, then you can't talk in the box.
He's been reporting with them for the last 18 months and has been consistent with his appointments with them, Judge. He started off with pills, oral medications, but now he's on the injection. He takes once a month and he's now currently stabilized. I believe the issue was a little miscommunication with probation. I know that probation wanted him to try to get help at Palo Alto. My client states that he went to Palo Alto to get help and they said, we can't double up on your care. You're already seeing the Center for Healthcare Services. My client has stated that he can't afford the UAs and the probation officer essentially said, figure it out. And we are figuring it out, Judge. His family's going to help contribute to that UA. So that's not going to be an issue. And I told clients that, no excuses in terms of not missing probation. If he needs to take the bus, he needs to take the earliest bus possible. So even if he misses a bus, he's on time. If he's there and they're saying they can't meet with him, to document that, to take a picture, he was there, email me, email the court. Hey, I'm here. The probation officer is not able to meet with me at this time. He's wanting to reschedule, but he has been making his appointments regularly with Center, Judge, and he has been doing well with them. So it seems like, he has a lot going on, but I'm telling him that he needs to make good on his requirements to the court and probation, that they need to meet with him, they need to see him. But his sister did furnish me that document from Center from Healthcare that he is receiving treatment, Judge. And I think he does seem stabilized to me. He does seem like he's wanting the treatment and he's already set up with the center. So we're respectfully asking the court for him to allow that. I did talk with him about the proposition before the court with meeting with probation. He has no issue going there down in person. He's going to take the bus. He's going to have family members take them. He's going to establish a better communication with the probation officer. I think has a year left after all the extensions when it's all said and done to expire in 2025 in April, Judge. So I'm encouraging him to give this last push. He's been on probation for quite a while. I think this case originated in 2016. So he has not picked up any new number ones. He has not demonstrated any violent behavior. He's demonstrated that he does need mental health services and he is, he is taking measures to help himself in that regard, Judge. So we're asking the court respectfully.
All right, and probation, I'm assuming that you all will have access to his compliance with Center for Healthcare Services?
Your Honor, we will ask for a release of information.
Oh, you have the release?
Yes, Judge, I filled it
Thank
out
you.
with him, just in case we need the records from Center.
All right. All right, so I don't think it would be appropriate for him to have to report more often than he's currently reporting, because it seems to me the issue is his mental health. So if there's no objections, what I'll do is I'll deny the motion, alter main conditions, and he's continue with mental health care with Center for Healthcare Services. you to make sure that you report monthly. You understand?
Yes, ma'am.
And you are to provide a release so that the probation will be able to see how your treatment is going for Center for Healthcare Services. The court will note for the record that that release has been signed. Is that correct, counsel?
Yes, Your Honor. We have executed that and
All right. Is there anything else?
nothing further, Judge. We greatly appreciate the court's time and consideration.
Thank you, ma'am.
All right, Mr. Ramirez, we're off the record. If there is an issue, you can always come to court and let the court know what the issue is, and we'll make sure that you're on track.
Okay.
You understand?
Yes, ma'am. I understand.
All right, good luck to you.
Thank you, ma'am, very much, ma'am.
All right, you're welcome.